Public access, both in the courtroom and also online. And first up, we've got the case of People of the State of Michigan versus Trevor McLeod, file 23-6748FH. Mr. McLeod, good morning. Sir, would you step behind the bar, please?
He's by counsel.
He's not a licensed attorney.
Do we have I demand my right to counsel.
Sir, step behind the bar or you're going to be taken into custody. You're not an attorney, so gather your things. You can step behind the bar. I'll be in a minute.
The papers.
So, Mr. McLeod, I first have to establish that you've told me before that you wanted to represent yourself. Are you changing your mind on that matter?
I'm bringing in my own counsel for the tribe, yes.
Is he an attorney licensed in the state of Michigan?
He doesn't have to be.
Yes, he does to practice in this court. So you're not wanting to represent yourself then? Am I hearing that correct? You want an attorney?
I have a right to counsel.
Yes, you do.
Doesn't have to be a licensed attorney.
Yes.
No, it doesn't.
In a courtroom, who do you think gets to decide that question? You or me? So me. And so you may be represented by an attorney, but it has to be a member of the bar in the state of Michigan. Now, I can tell you, I read your motion and Mr. Delpy's purported appearance, which is not authorized. And it seems to me that perhaps you want him just to explain some things to the court about the consent decree.
That's right.
Now, for that purpose, in your motion, you may call him as an expert witness on that question, and he can offer testimony on your behalf as a witness.
Okay.
But I can't allow him to make arguments on your behalf or represent you in the case.
Well, that's why we put it in for limited.
Okay, so you just want him to offer some testimony about that stuff?
Sure.
Okay, so we can do it that way, and he can testify as a witness. There's no problem with that. Assuming that he meets the requirements for a witness and, have to follow the rules of evidence and all that.
Sure.
All right. So with that in mind, then, I need to confirm, are you still desiring to represent yourself?
Yes.
Yes, you are. Okay. All right. So we are here on your motion to suppress. There is in the court file a preliminary examination transcript, so I did have an opportunity to review that, and I'll take judicial notice of those proceedings. So then I suppose we can take supplemental proofs. So Mr. McLeod, I guess, at the preliminary examination, the conservation officer testified about his actions and observations that day. Did you wish to have him offer further testimony about that, or do you want me to just rely on the transcript of the preliminary exam?
I think we have to rely on the transcript.
Okay, Mr. Juliet, do you wish to supplement that in any way, or?
Just very briefly, and I believe he's on Zoom for testimony, that's okay.
Okay. Any objection to that, Mr. McLeod?
Object.
What's that?
Object.
What's the basis for the objection?
That his testimonies, I've already got proof of perjury here.
Well, that doesn't tell me why he shouldn't be allowed to offer some additional testimony.
Because it's not valid. You can't trust it. He's already lying.
He's what?
He's lying.
Well, again, that's a different problem. I mean, if a witness testifies falsely under oath, that's serious problems for the witness. But the prosecutor's saying they want to offer some additional testimony by the correction officer. So I'll allow that, and then you can cross-examine them, and then you can present witnesses in your own defense. Good morning, sir. Can you tell me your name?
Alexander Bourgeois.
Thank you. Where do you work?
I currently work for the Michigan DNR in the Law Enforcement Division.
And how long have you been working there?
Since August of 2022.
Were you working on September 4th of 2023?
I was.
And are you familiar with the defendant in this case, Mr. McLeod?
Yes, sir.
Did you have contact with him that day?
I did.
And what was the reason for the contact?
We originally made contact with him because he had expired boat registration on his vessel. Upon making contact with him, it led to the arrest of him for voting under the influence.
Okay. Was there anything else that drew your attention to the defendant?
Yes, we originally made contact with him at the boat launch.
Hang on. There was an objection. What's your objection to that question?
They're trying to add testimony to the statements in the original testimony. That's not stated.
Well,
They're trying to change the story.
Okay. Well, they are allowed to present, testimony here today, and I agree that's exactly what they're trying to do. They're trying to supplement the record and give me some additional information that wasn't in the attachments or in the prior transcript. That is permissible, just like you're going to be able to offer further testimony from what you gave in the district court. So I'll take all those things into account. So that objection's overruled. Go ahead.
So I'll just repeat myself, officer. Was there anything else that drew your attention to the defendant?
Yes, when the defendant docked at the dock along the river, when he got off the boat, myself and the other conservation officers, we realized that he had difficulty getting off the boat, that he had to hold the post to get off of it. Once he had gotten off of the boat and he walked towards the bathroom, he stumbled and swayed up the dock and ramp, and stumbled and swayed on his way back. That's when I made contact with him about the boat registration. And once I asked for the registration for the vessel, which obviously would be inside of it, he struggled to put his sandals back on longer than a normal person would. It took him about 10 seconds to put on a simple sandal. And then once he got into the boat, I noticed that he had lack of fine motor skills that would be common with somebody that's under the influence. I noticed that he had slurred speech. And then he also, I could tell that he showed just general signs of someone that might not be completely sober.
Okay. As part of your training as a conservation officer, do you receive any training in OWI related boating incidents, I guess?
Yes, we're trained in both normal motor vehicle, and then I myself am trained in BOI.
Okay. And before you, I guess, approach, can you explain the timeline of events? Did you notice any signs of intoxication before you made contact with the defendant?
Objects.
Hang on, there's an objection. What's the objection? What's that? I'll sustain that. Maybe you can ask him, when did you notice any?
Officer, when did you notice the signs of intoxication?
I noticed it as soon as he tried to get off the vessel, when he was stumbling and was having difficulty getting off of it. The water wasn't rough or anything that would cause any type of equilibrium imbalance. It was a calm, flat river, so the defense of that wouldn't be valid in my opinion. So when he's stumbling to get off of the boat and then stumbling up the dock, it would show that he would be impaired on something rather than from the water.
Where were you when you noticed this?
5 feet away from on the other side of the dock. I had clear vision of it all the way up the ramp too.
And did you approach him after you noticed these signs of intoxication?
Yes, sir.
Okay. Did he, when you made contact with him, did he inform you that he was a tribe of a member of a Native American tribe?
No, sir. Nor did he advise me that he was in the.
Hang on. There was an objection, and Mr. McLeod, it might help a little bit if you would state your objections a little more loudly, so that the witness who's testifying remotely can hear that. The question was, did he tell you that he was a member of a tribe?
Yeah.
And there was an objection. The reason
He's leading the witness. He's leading the question.
Well, I think that I'll overrule that. That doesn't suggest what the answer is. He's saying, did he tell you? The answer could be yes, it could be no. So that'll be overruled. Go ahead, Officer Bourgeois. Did Mr. McLeod inform you of his membership in any Native American tribe or band?
No, sir. He didn't advise me that he was tribal, nor did I see him in the act of fishing. And either way, as a conservation officer, I have the right to make contact with him. And upon that contact, I would have observed his signs of intoxication. So
right, I'm going to strike hang on. You've done way more than answer my question. I'm going to strike everything you said after no.
Okay.
All right, just answer the question. Thank you. All right, go ahead.
So can I just repeat?
Yeah. No, you don't have to, I mean, it's asked and answered. I heard the answer is no, we didn't tell him.
Okay.
So go ahead.
Did you see any evidence of fishing related activity?
No, sir.
I have no other questions.
All right, Mr. McLeod, do you have questions for Officer Bourgeois?
Yes.
Go ahead.
Have you ever seen him walk before?
I'm sorry, can you repeat? I'm sorry to hear you.
Have you ever seen me walk?
Ever seen you walk? No, sir. The first time I made contact, I've ever seen you in person was on that day.
Okay. Are you aware that I've had a double hip replacement?
No, sir.
Okay. So you made a determination that you, what's your basis for comparison of how I walk and what my gait might look like?
I would base it off of a normal human being. I mean, we see people walk every single day. So if someone's swaying, stumbling up a ramp, walking side to side along the ramp, struggling to use fine motor skills just to put their foot in a sandal, I would assume that would show signs of intoxication.
Well, you never asked if I was disabled or previously disabled.
No, but that would have been part of my questions upon doing the test. I would have done a medical screening, which you refused to do.
So you state in your testimony that your partner fell on top of me.
Yes, sir. When during the wrestling to get your hands behind your back, yes, he fell on top of you while you were resisting.
And you also state in your testimony that your partner advised me to put my hands behind my back, but I refused. Is that correct?
You did. Yes, sir. Yep.
You also state in your testimony that your partner was able to actually just cuff me without me complying. How did that go down?
I'm sorry, I couldn't hear after the cuff part. What was that?
Your partner was able, you state in your testimony that your partner was able to actually just cuff me without me complying. How did that happen? Explain that to me.
He grabbed one arm, cuffed it, and then you refused to comply. You continued to keep your other arm away from him. You actually were laying on it with it underneath your chest, and he ended up able to roll you over, grab your arm, and then pull behind your back and cuff you without you ever complying.
You also state in your testimony that you advised me that I was under arrest for boating under the influence. Is that correct?
Yes, sir.
When did you advise me of that?
Before we even entered your vessel, we told you to step out, that you'd be under arrest for boating under the influence, and you stated no, which would be further resistance because it was a lawful order.
No further questions.
Heard any redirect?
No.
Right. Thank you, officer. So do you wish the officer to, well, we should probably remove him from the meetings in case there's a trial. Then. All right. So Officer Bourgeois, thank you for your testimony here today and your excuse.
Thank you, sir.
Okay, Mr. McLeod, do you wish to present any witnesses in support of your motion to suppress?
No. Oh, yes, I wish to present Mr. Belkey.
Okay, Mr. Belfi, you want to come out to the witness stand, sir?
And for the record, I think it should be Dr. Belkey.
Oh, okay, I'm sorry.
Okay.
That's fine. I forgot. Dr. Belfi, please raise your right hand for me. Do you solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you
I
God?
certainly do.
Okay, you can be seated. And can you state your name for the record and spell your last name for us, please?
My name is Dr. Phil Belfi, and the spelling is Bellfy.
Okay. All right, thank you, Dr. Belfi. Mr. McLeod, go ahead with any questions you have.
Mr. Belkey, could you explain to the prosecutor who holds jurisdiction in
Could you give me that one piece of paper?
For a legal conclusion.
Hang on, there's an objection here. So, Mr. McLeod, I mean, you're doing fine in representing yourself. I guess I'll sustain that objection. How you need to proceed with an expert witness first is ask Dr. Belkey some questions about his education background in the area, and then the prosecutor will have a chance to do some follow-up questions if they see fit. And then you would ask the court to recognize Dr. Belfi as an expert in a particular area. And then if that's accomplished, then you can ask him his opinions in that area. So why don't you go ahead and just start and ask him a bit about his background.
Mr. Belfi, what is your area of expertise?
I have a PhD in American Indian Studies. It's not called that, but that's what it is. And I am professor of American Indian Studies for Michigan State University. I'm retired now, but I'm professor emeritus of American Indian Studies. And I've also been qualified and admitted to practice tribal law in the Sault Ste. Marie Tribal Court. And my entire academic career has been involved with treaty issues and court cases and those types of things. So I don't want to be real vain about it, but I would consider myself to be an expert.
Do you have familiarity with how the tribes that are parties to the consent decree have implemented the provisions about boat and vehicle and snowmobile registration? In other words, my question is, do the tribes issue their own registration for any of these vessels, or
Not that I'm aware of.
so in your, have you represented in tribal courts,
Absence. I'm sorry.
object to what?
To you trying to interpret the consent decree.
Oh, I'm not trying to interpret the consent decree. I'm asking Dr. Belfi his opinion about it. Just, the court is allowed to ask questions. So Dr. Belfi, the tribes don't issue registration for vessels?
Not that I'm aware of, no. But they do issue, if you're a tribal member like Trevor, they issue you cards
Yes.
that show that you're a tribal member, you have the right to do whatever it is that you get a permit for.
All right. Do you have any knowledge about, I'm going to ask this. If non-tribal law enforcement sees a vessel with no registration or expired registration, do you have any experience or knowledge based on your studies of the consent decree about how that's handled, how law enforcement is supposed to recognize if something is a tribal vessel and not subject to it, or a non-tribal vessel subject to it? And if you don't know, that's fine. That's a question for me to ask the parties' arguments, but if you have any knowledge about that.
I do have some knowledge in that, yes. If the non-tribal law enforcement officer can try, the instant that person or anybody discovers that the person is a tribal member, that's when the jurisdiction ends. According to everything that I've read and everything that I've learned, when it's cross-deputization arguments. If, for example, Trevor was taken downtown, taken to this building, I suppose, people who were in the building, presumably, knew that he was a tribal member. It was at that moment that the jurisdiction transfers from this particular court to the tribal court. And that's what the cross-deputization is all about.
All right, thank you. Any further questions as a first question, Mr. McLeod?
No further questions.
Any further questions as a result of the court's question? Okay, thank you, Dr. Belfi. Mr. McLeod, do you have any additional witnesses you wish to present or evidence?
No, thanks.
All right, anything else, Mr. Juliet? No, thank you. Mr. McLeod, it's your motion to dismiss. I have reviewed your motion and your reply to the prosecutor's response, but now you also have an opportunity to make any argument you want in support of your motion. But
I'd like to submit this. I was told to play a disc for the court today.
so what is that?
It's a video of me being on the boat and the officer stepping onto the boat and me putting my hands behind the back of the boat.
Is there body cam footage?
No, it's a Snapchat that one of my guests filmed.
Okay, has the prosecutor had an opportunity to review
Yes,
that?
they've had it since September.
Okay. Any objection to that being admitted?
No, that's fine.
Okay, so if we can mark that as defense exhibit 2. Do you know how long that video is?
10 seconds. I think that's 7 seconds.
7 seconds. So 2 is admitted. Well, what we could do is we could take a 5-minute recess for me to,
Well, can I submit this along with it so you can take this into recess with you?
well, what is that?
This is part of Officer Bourgeois' testimony from my preliminary hearing.
Well, I have the transcript. You can just tell me what page.
It's page 16 and it's line 7, 8, and then, well, there's other lines in there, but that's the main one I want you to look at.
Okay,
Line 7 and 8.
page 16, starting at line 7, the court can take judicial notice of the records in the court file, including the preliminary examination. So you want me to kind of view the video in context for this testimony and compare the two?
Yes.
Okay, so what we could do is I can take a 5-minute recess. I can't play it on this computer, but I'll go and watch it and come back in 5 minutes. Thank you. All right, thank you. I've had a chance to watch Defendant's Exhibit 2 and compare it to the testimony of the officer on page 16 of the preliminary examination transcript. Mr. McLeod, go ahead and make any additional arguments you want in support of your motion to suppress.
Well, I think that we need to impeach that whole officer's testimony because he's clearly lying from the facts of what happened that day. And he's lying under oath, which is perjury. So that's my motion is to impeach everything that he said.
All right, thank you. Mr. Juliet?
I guess I would just first take note that this is what I view as a motion to suppress based on unconstitutional stop. The case on point is Terry versus Ohio, which states that a temporary investigative detention may be based on reasonable suspicion when an officer observes unusual conduct which leads the officer to reasonably believe in light of his experience that criminal activity may be afoot. The officer testified that he was on patrol on the Sheboygan River. Then he observed the defendant's boat registration to be out of date. Upon further observation, he observed what he testified to be signs of intoxication. I think that alone satisfies the reasonable suspicion test. As to the...
I object, and the reason why is because I'm showing that this officer, his testimony can't be trusted.
Okay.
So how can we trust the fact that he's saying I observed this or I observed that when he's lying?
Okay, and that's more in the form of a rebuttal argument than an objection. So Mr. Juliet can make his argument, and then you as the moving party, you'll have a chance to make a rebuttal argument. Continue.
So just as to the inland consent decree, I did misquote in my original response that the defendant must present evidence. I did submit a amended response. He only needs to possess that evidence.
Change the word.
When the officer made contact with the defendant, he had no idea he was Native American. He didn't see any fishing gear or anything like that. So I don't think that the inland consent decree really shields the defendant in this case.
Well, can I ask you, so do you concede then, so let's say they make contact with them and they learn that he's a member of the, are you a member of the Sioux tribe? He's a member of the Sioux tribe. They can't write him a ticket for the unexpired, for the expired registration, correct?
Well, I can answer that in two ways. Based on my understanding is that he would be shielded from civil infraction ticket if there's possession of some sort of fishing gear or something like that. But based on Dr. Belfie's testimony, I think that unless the DNR officer has some knowledge that he's a member of a Native American tribe, I don't think that can be imputed to the officer to just automatically know that he's a member.
Okay. Can I ask you, have you seen this 6-second video clip?
Yes, I have.
What am I to make of the fact that that appears to depict something different from what is described by the officer's testimony at page 16?
Well, I don't think it describes that at all. I mean, that's a video that they're on the dock. The RNO happened in the boat. So
No, this is in the boat, and the video shows Mr. McLeod standing there talking to the officers, engaged in some conversation with them. The officer steps aboard, stands behind him, and grabs Mr. McLeod's hands, and both hands are being brought behind his back, certainly by the officer, though with no apparent resistance from Mr. McLeod.
okay. Well, to that, if the court's going to, I guess, ask that question, that's a question of fact, the right to resist an unlawful arrest at a jury or bench trial.
No, I'm saying I didn't see any resistance.
What would
There's
you,
testimony that he did resist. I mean, the video is only 2 seconds long.
Thank you. Mr. McLeod, any rebuttal argument?
like Mr. Belvey testified, this document's not open to interpretation by anybody in this room. It has to go to the Western District of Michigan. And certainly not Mr. Juliet has any qualifications to make any interpretations on this document. The 2007 consent decree.
Great, thank you. Well, Mr. McLeod has filed a motion to suppress the evidence because of essentially an illegal stop or search or seizure. Some of his arguments sort of blend into a motion to quash for lack of evidence as well. In terms of the suppression, so there is evidence in the record now and testimony about this 2007 consent decree, and that Mr. McLeod is a member of a tribe that's a party to that consent decree that would shield him from prosecution for or from laws regarding registration vessels if he possesses evidence of fishing or whatnot. We're not here on an expired registration matter. If we were, Mr. McLeod may well have valid defenses to that. What we have is a non-tribal law enforcement officer sees a vessel underway on navigable waters and sees an expired registration kit. So I think that gives the officer reasonable suspicion to make contact with the operator of that vessel. And that's consistent with Dr. Belfie's testimony as well, that they can make the contact, and then as soon as they know there's a issue, then, at some point, that their jurisdiction to enforce that, may divest. And I understand Mr. McLeod is saying, well, they never gave me an opportunity to tell them that because we're right in the middle of it, right from the initial contact. But be that as it may, I think the testimony, including from Dr. Belfie, is law enforcement, they don't know if something's a tribal vessel or not, whether it's operating under this consent decree or not. They see a vessel on the waters of Michigan with an expired registration. They're allowed to make contact with that person to find out what's going on. The officer did testify that even before making contact with Mr. McLeod, they observed what they thought to be evidence of impairment. So that's the initial contact is not a constitutional violation, nor is it a violation. It doesn't appear to be a violation of the consent decree either. It's the initial contact, and there's evidence of the impairment right there. So now they're beginning an investigation for impaired operation of a vessel.
Well, I object, Your Honor. I want you to take a look at the MCL, the Michigan compiled law that has to do with this OWI on a boat.
Oh yeah, you weren't
Section-
operating.
Yeah,
Yes,
it's not.
and I've reviewed that argument that Mr. McLeod says he wasn't operating. And he's correct that he wasn't operating the vessel at the time they made contact with him. You're right.
Yeah, the docked and tied off and shut up, keys right.
Right. But they did The testimony.
Well, I object to their testimony being invalid. They're lying. I've got proof of it.
Well, I've heard the arguments. I let you make your arguments, and now I'm making my ruling. I lost my train of thought. That's right. So they don't, at the time they make contact, Mr. McLeod is not then operating the vessel. But they did testify that they saw him observe, that he's at the helm, it's under throttle, because the flow of the river would mean that it would have to be under throttle to approach the dock in that direction. They saw him with his hand at the helm and at the throttle. So they observed him operating.
They observed me operating with a beer in my hand or drinking. And also,
I need to make my ruling. I need to make a record without this just back and forth.
okay, but I want to make part of the record too, is that we were sitting at that dock drinking alcohol and beer before those guys pulled up to us. So there's no way they can determine.
Okay, well, that's a different issue. You know, doing this one at a time.
Yeah.
So that they're allowed to, they observe him operating the vessel. They're allowed to make the initial contact because of an expired registration. Before, as they're making that contact, they see evidence of some impairment and begin an impaired operation of a vessel investigation. That's all lawful. And so for that reason, the motion to suppress evidence for an unlawful stop or seizure is denied. And to the extent it's a motion to quash the information or dismiss because of lack of evidence of resisting or lack of evidence of operation, there's at least probable cause of that to support the bind over from the testimony. He's resisting the commands to leave the vessel. They do complete an investigation for the impairment. Now, Mr. McLeod certainly has some evidence to support his defenses, including the video that I watched that does, it's just a snippet of time, so that I can't dismiss the charges based on that video, Mr. McLeod, because it doesn't show me everything they have.
But it shows you the officer perjured himself.
Well, you're going to get to show that to a jury.
Sure.
Okay. And
so that's where we're going.
yes, so I'm going to deny your motions to dismiss or suppress based on the law because the officers had a right to make contact, and they say that the evidence of impairment was evident on that initial contact. But these issues are all things that you can present